Okay, there it comes a little bit.
Welcome back to Hot AF. I'm your host, Scott Ferriss. Today I'm joined by one of our associates, Casey Brown,
Hi.
who's here to talk about just some general workers' compensation stuff. And Casey is a known chicken aficionado, so today we are not actually eating chickens because that's not great for being a chicken aficionado.
Mm.
We have plant-based chicken, and I tried a piece earlier, and it's actually very good. So I'm excited for this. This is a new experience for me as well. Um, but let's just go ahead and jump on into some flowers and plants, huh?
Hit me.
All right. So one of the things that comes up a lot that we get questions about is the 3-day waiting period. And can you just explain what that 3-day waiting period is and when it applies? And we're gonna try some plant here, plant chicken plant. If you were to plant a chicken, this is what would come up. But this our first one is a jalapeno based hot sauce from a local restaurant called Chimborazo, which is actually Casey's one of her favorite restaurants.
Mm.
Top 10 hot sauce of all time
Mhm.
for me. That one is so good.
It is really good. Okay, so 3-day waiting period. Temp total isn't payable for the first 3 days after beginning a period of disability, unless the disability continues for 10 days or more. At which point, then those first 3 days would also become payable.
So you got to wait the 10 days before those become payable, and you wouldn't issue payment right away unless you know for certain that it's an injury that's going to be out for more than 10 days.
Right.
But then you just retroactively go back and issue the payment, right?
Exactly.
Got it. Our second one that we're going to try here, and then we're gonna talk about appeals a little bit because you worked on a lot of appeals, including one recently that dealt with a chicken. But the second one we're going to do is a hot sauce from Mexico. It is it's tamarind and habanero based. It's a little sweeter, not as creamy as that first one, which is really good. But this one's got some heat that'll build up a little bit. So you're at a hearing. What do you need to do to preserve an issue for appeal to the Court of Appeals?
So that's something you absolutely want to do. I'll use an example of an IME report. So you can't go up to the WCCA and object for the first time to the foundation of an IME report. That's not going to work. You need to do it at the lower court level.
Is that an affirmative thing that you need to say on the record, or can you note it in any written submissions?
Yeah, you could do both. The most applicable time would probably be during a hearing when the judge is, entering all of the exhibits.
Going through that pre-trial process, talking about all the exhibits, right?
Exactly. So again, with my example of an IME report, that would be the time to say, I object to the foundation of this IME report.
Got it.
Because you don't want to lose that ability to.
Is there any way to appeal something if it's not objected to at the hearing level? If it's specifically with evidence, let's just stick with that.
Mm-hmm. You can certainly try. It's probably not going to be successful, though.
All right.
If there are certain circumstances where something didn't exist at that time, then you might be able to sneak it in that way.
Okay, got it. Our third hot sauce we're going to try is Truff, and this is their hotter, which is supposedly they call it hotter than their original. I think they're about the same, but very, very heavy truffle flavor, which I personally very much enjoy.
I do too.
I want to ask about first reports of injury and when an employer is bound to report that to their insurer. And is there something in particular that triggers that?
Mhm. This one's nice. Okay. So, generally, an employer needs to report an injury within 10 days um, once they, become aware of it. There's an exception for any death or serious injury that does need to be reported within 48 hours.
It's any event that's reported by an employee, correct?
Yeah,
And then the employer should be submitting the first report of injury, or the insurer should be reporting that at that time.
exactly.
Got it.
Yes.
Um, Next, I want to try. This is an Icelandic hot sauce that was brought back from Iceland by one of our partners here, and it's I believe it is a smoked hot sauce. Um, we learned that the iPhone does not translate Icelandic well, so we don't know exactly what is in it. But
We'll find out.
it's
Maybe.
good, I think. But when we're dealing with intervention claims, we deal with this all the time, and
We sure do.
they come up all the time. Even after you think you've covered everything,
Hmm.
somebody will always appear. What is the process, or when should we be putting interveners on notice of right to intervene, and who is responsible for doing that?
Hmm.
It's very
Interesting, but I
smoky.
like it.
Hmm. It's very smoky.
Hmm. Okay. So, if a matter is in litigation, then any party who knows or has any, reasonable suspicion that a party might have an intervention claim needs to put them on notice. I feel like it's better to cast a wider net
It's
rather than not do it and potentially miss somebody, because then that can just cause settlements to drag out and drag out and drag out.
and is there and that's like you said, it's any party, so it could be the employee or the insurer,
Yep,
correct?
exactly.
It's not, it doesn't fall on one or the other.
Right.
Um, okay. And what is the kind of the process once you send that notice? What happens next?
The intervener then has, by the rule, 60 days to file a motion to intervene. Sometimes they don't do that, but it'll still usually get let in. Um, and then at that point, they have to prove their claims. So they have to submit an itemization of all of the details. And, we go over those things and make sure that they're actually related to the work injury, because sometimes they add everything in there. So it's important to check those.
Got it. The last thing I want to ask about after we talk here for a second, this is a ghost pepper and prickly pear hot sauce from Arizona, that my parents actually brought back for me. Um, this is going to be our hottest one. I think it's good, but it's got some good heat to it. Um, but
We will find out.
if we have a dispute between two insurance companies regarding, let's say there's two dates of injury, and the insurers are fighting against each other of who is responsible for the employee's current ongoing condition. Um, what is the process, or what part of the statute governs that dispute?
Okay, there it comes a little bit. um, so this is governed by statute 176191. And like you said, this is where different parties are kind of playing hot potato with the claim and who's responsible for it.
Hot plant chicken.
Hot plant chicken. So at that point, they will, you can have a hearing to determine who's going to be the responsible party. And then once that is figured out, interest is going to be due at a rate of 12%. So the parties who's reimbursing will have to
Has
pay
to
that.
pay.
plus interest, plus the employee's attorney's fees. Also,
So all of that gets added on top, assuming the employee has an attorney
yes,
at that point.
exactly.
Got it. Okay.
Yeah.
Well, I appreciate you coming by and trying some plant chicken
Thank you.
and some hot sauces. That last one is starting to hit now.
It is a little bit, yeah.
So I'm breathing a little heavier, which is good. That's what we like to have. And thank you again. Don't forget to smash that like button and preserve those chickens.
Eat a fake chicken, not a real chicken.
Yeah.
They're tasty.
We'll see you next time on How to AF.